I'm not, Noah's starting, I'm going second.
Okay, well, we'll keep extra information as well.
Okay.
Go ahead.
Ewa Krajewska, partner at Henein Hutchison LLP and counsel to the Canadian Civil Liberties Association.
Correct spelling.
EWA, Krajewska.
Beautiful.
I'm Noa Mendelsohn Aviv, Executive Director and General Counsel of the Canadian Civil Liberties Association.
And your spelling?
NOA. Mendelsohn is MENDELSOHN. New word, no hyphen, AVIV.
Thank you very much.
And you can use whatever pronoun you want, but I go with she, her.
Perfect.
Okay.
Okay, 30 seconds.
Operator, the line is unmuted.
Please proceed when ready.
Okay, we're ready to go.
Good afternoon, everybody. My name is Noa Mendelsohn Aviv. I'm the Executive Director and General Counsel of the Canadian Civil Liberties Association. Thank you for joining us today, and an enormous thank you to CCLA's extraordinary legal team, Ewa Krajewska, who you're going to be hearing from in a moment, Brandon Chung, Matthew Gourlay, and Abby Deschman, and to the generous support of Henein Hutchison, who is hosting us here today. Yesterday, the Federal Court of Canada handed down a massive victory for rights and freedoms in Canada. The Canadian Civil Liberties Association understands that careful and responsible democracy requires checks and balances to protect all of us. We need it to protect us, and we need it to protect our fundamental rights and freedoms. But in February of 2022, the government invoked emergency powers using the never-before-used Emergencies Act. This was done on the background of a massive blockade in Ottawa, as well as a number of border blockades that had already been dealt with or were just finished being dealt with by police services. CCLA's legal challenge, to be clear, was not about the blockades in Ottawa. These blockades had caused serious hardship to the residents of Ottawa, and in particular hardship to marginalized, racialized communities who had faced intimidation, harassment, and threats from certain of the protesters. These blockades had gone on for too long and needed to be addressed. The question we had was not whether, but how. CCLA's concerns, our challenge that led to yesterday's decision, were about the government giving itself massive and extraordinary emergency powers. Powers that may be necessary in a serious and extreme situation of a true national emergency as defined by that law, but were unreasonable in the circumstances. Emergency powers are useful in emergency situations, but they are also dangerous for all of our rights and freedoms. And with that, I'm going to turn it over to Ewa Krajewska to tell you more about the decision.
Good afternoon, everyone. The federal court decided that the decision to invoke the Emergencies Act did not meet the legal thresholds set out in the legislation. First, it was not a national emergency. This means that the existing laws of Canada were sufficient to deal with the crisis. The Emergencies Act is an act of last resort. It should not be invoked for convenience or expediency. Second, the situation did not rise to the level of a serious threat to the security of Canada, as that term is defined in the CCLA Act. The government argued that the economic repercussions of the blockades satisfied that definition. The court did not accept that argument. A serious threat to the security of Canada means a serious threat of violence, not economic harm. Now, some of you may have asked yourselves, but didn't Justice Rouleau, who headed the Commission on the Public Order Emergencies Act, find that the decision to invoke the Emergencies Act was reasonable? He did. But the Commission and the Court play different roles in holding the executive to account for their exercise of this extraordinary authority. The Commission's mandate was to find out what led to the protests and what led factually to the invocation of the Emergencies Act. While the Commissioner found that the threshold was met, he was clear in his decision that reasonable people could disagree with him and that he was not making a strict legal finding. That was the role of the court. The court was looking at whether the legal definitions and the legal thresholds were met when invoking the Emergencies Act. This decision is really important. It sets out the guidance for future governments on when they can invoke these extraordinary powers. It provides legal clarity. It provides transparency. We recognize that living in a democracy with independent courts, that review of government action by the courts provides transparency and cogent reasons for the public to understand what happened. It also sets out clear checks and balances for future conduct. I also want to note that the court recognized the really important role that public interest organizations like the CCLA play in bringing these matters before the court. The invocation of the Emergency Act had been revoked. All of this was a distant memory. The government argued that the whole case was moot. But the decision is also forward-looking, as it sets out how the law should operate in the future. The court recognized in its decision the important role that the public interest groups like the CCLA played in bringing this matter before the court. The CCLA has never been more needed than today to protect our democracy and the rule of law, especially with regards to the threats we see globally to democracy, the rule of law, and the independence of the judiciary. Okay. Maintenant, je vais parler de la décision encore une fois, mais cette fois-ci en français. Donc, la décision d'avoir recours à la loi sur les mesures d'urgence ne respectait pas le seuil juridique fixé par la législation, tranche la Cour. Il ne s'agissait pas d'un état d'urgence national au sens où les lois existantes au Canada étaient insuffisantes pour faire face à la crise. La loi sur les mesures d'urgence est une mesure qui doit être employée en dernier recours, pas pour des raisons de commodité ou d'opportunité. La situation ne constitue pas une grave menace envers la sécurité du Canada au sens de la loi sur le service canadien du renseignement de sécurité. Le gouvernement a fait valoir que les répercussions économiques ne répondaient pas à cette définition. La Cour a estimé que ce n'était pas le cas. Il doit s'agir de graves menaces de violence. Vous vous dites peut-être que le juge Rouleau a tiré des conclusions différentes à l'issue des travaux de la Commission sur l'état d'urgence. Oui, la Commission et la Cour jouaient des rôles différents dans l'examen de la décision du gouvernement d'appliquer la loi sur les mesures d'urgence. Toutes deux constituent des freins à l'exercice par le gouvernement de ce pouvoir extraordinaire. Le mandat de la Commission était de déterminer ce qui avait conduit aux manifestations et ce qui avait conduit, dans les faits, à employer la loi sur les mesures d'urgence. Si le commissaire a estimé que le seuil était atteint, il a clairement indiqué que des personnes raisonnables pouvaient ne pas être d'accord avec lui. C'était le rôle de la Cour. La Cour s'est penchée sur la question de savoir si les définitions et les seuils juridiques pour avoir recours à la mesure d'urgence avaient été respectés. Cette décision est déterminante pour orienter le gouvernement à l'avenir si jamais pareille situation devait se reproduire. Elle apporte une clarification juridique. Elle assure également la transparence. Nous reconnaissons les avantages de vivre dans une démocratie dotée de tribunaux indépendants qui passent en revue l'action du gouvernement et assurent la transparence et l'exercice des motifs convaincants pour le public. La Cour a également reconnu le rôle important que jouent les organisations d'intérêt public dans l'avance de ces questions. Le recours à la loi a été révoqué. Le gouvernement a fait valoir que la cause était devenue caduque. Mais les aspects prospectifs de la décision sont également essentiels à l'examen du fonctionnement de la loi conformément à son intention. La Cour a mentionné explicitement le rôle important que les groupes d'intérêt public comme l'ACLC ont joué en portant cette affaire devant les tribunaux. La CLC n'a jamais été aussi nécessaire. Merci.
Merci, Eva. Yesterday's federal court decision is not only an important victory for democracy today, but it has significant implications for the future. This and every future government is on notice. First, use of national emergency laws require extreme circumstances that meet the strict definition, the high bar that was set out in the law as found by the federal court. Second, all future governments need to know that even in times of crisis, especially perhaps in times of crisis when emotions are running high, no government is above the law. Third, even in times of crisis, basic rights and freedoms must be upheld. They must be protected, and it is necessary and demonstrably justified to limit them, and that limit has to be as minimal as possible. Finally, that CCLA and all of us who care about and are concerned about rights and freedoms are paying close attention. We will not stand by if this or any future government gives itself emergency powers unreasonably. We will not stand by if government overreaches. We will speak up in the face of unjustifiable charter violations. And for 60 years, CCLA has demanded accountability from governments. And we will continue to do so and to take action when necessary to protect the rights and freedoms of people in Canada. Governments need to know that CCLA is not alone. We are supported and we are joined by countless people across the country. Yesterday's historic victory was won through the exceptional work of our incredible legal team, Ewa Krajewska, Brandon Chung, as well as Matthew Gourlay and Abby Deshman, superb and dedicated lawyers. There were other parties who filed their challenges, and there are countless ordinary Canadians who joined us, who supported us, who reached out to us, and who deserve their fundamental rights and freedoms and understand that these are best protected by a democracy with careful checks and balances on government power. This was not the first time that CCLA challenged the use of emergency laws. We were there in 1970 to challenge the federal government's using the earlier emergency law, the War Measures Act, and we were shown to be right about that and about the many rights violations that ensued, which is why we were there again before Parliament in the 1980s to argue for a better, stronger, tighter emergency law that sets a high threshold, the threshold that was recognized in the federal court's decision yesterday. It's a law that also maintains protection for charter rights. Our work for rights and freedoms continues. We will continue to work with and for people across Canada. In this emergency powers appeal and in our many other cases in advocacy, fighting for justice, privacy, equality, and freedom. Without equality, no one's rights are safe. Without expressive and protest rights, we cannot stand up for ourselves and others. Without the right to conscience, religion, and liberty, we cannot be who we are, make our own choices, and demand change. And without careful and reasonable democracy, all of our rights and freedoms are threatened. That is why CCLA fought this case. That is why it is a historic victory for us all. Finally, the Government of Canada announced yesterday that they would appeal the ruling. I want to be crystal clear. We will fight them, tooth and nail, at the Federal Court of Appeal. We will defend our historic victory for rights and leave no stone unturned. Today, I'm announcing that CCLA is reuniting the Dream Team to fight the federal government's appeal. I am proud to announce and sincerely grateful that Ewa Krajewska and Brandon Chung of Henein Hutchison Robitaille have been re-enlisted and have agreed to fight this appeal on our behalf. They are an extraordinary legal team, and I am confident that we will prevail at the Federal Court of Appeal. We are truly grateful for their expertise and prowess, and we are confident about the next step. Thank you.
We'll now go to a question and answer period, starting with those that are in the room.
Matt Saladina, Toronto Star. Given the yesterday's decision, are there any plans to file a lawsuit against the government? To sue the government, given yesterday's decision, are there any talks about that, any plans?
No, the legal action that we filed a year ago is the action that we've been pursuing, and we're going to pursue it on appeal as well.
Are you confident with this ruling that this will, governments in present or in the future will take heed and warning if a situation this comes up again?
I think we've sent a very strong message through our activism, through speaking out, through being in the public, through taking legal action, through being at the Commission of Inquiry. I think we have certainly put this and future governments on notice, and that was our intention, as well as to challenge the legality and the constitutionality of what we saw to be an unreasonable use of the Emergencies Act. So yes, I believe that they will have to pay attention to what the Act required, which is necessary for rights and freedoms protection.
Just to clarify, for people that may be impacted, business that were impacted, what kind of messaging are you telling them? What should they take away from this?
What do you mean by people who are impacted?
People that are impacted by protests,
In Ottawa.
yeah. In general.
Well, I think the takeaway is that the government and the police have the necessary powers to deal with protests under existing laws, and they do not need to invoke the Emergencies Act to deal when protests get out of hand or cross the line into what is not peaceful assembly.
And at the same time, I would add that disruption is a reasonable amount of disruption is present in many protests. People standing up for all sorts of different rights. And it's necessary that we live with that in order for people to be able to express their opinions. So where that line is crossed, perhaps there is justification, but it has to be demonstrable, it has to be specific, it has to be as limited as possible.
For viewers and readers who maybe aren't they're not legal experts, could we break down what those existing powers and laws are that would have granted them to act? Could you just break that down specifically, just so people can be aware of what that word means?
Well, the criticism that Justice Mosley lays in his decision is that, and also that Commissioner Rouleau found, was that the police could have relied on the criminal code and municipal bylaws that should have been enforced during some of the aspects of the protests.
And at the end of the day, it was a law enforcement organization and system that took apart the blockades.
Okay, no further questions from the room. We're going to go to the lines. Operator, if you could open up the lines for those that would have signaled.
Next question is from Ellen Brusetti at La Coop de l'Information.
Yes, good afternoon. And just before I ask my question, please identify yourself before answering, because over the phone it's difficult to determine who's talking. So my first question would be could this decision could potentially open the door to financial compensation, especially for those who saw their bank accounts being frozen?
Okay, so it's Eva. I'll answer this. There is no certain answer to that question. There actually was a case before the Supreme Court in early December called Power as to whether a person could bring a lawsuit against a government for monetary compensation for a law that was found unconstitutional. And that's on reserve right now at the Supreme Court, so there is no answer right now, but maybe there will be in the coming year.
Okay, I get from what you're saying that depending on that result, the answer could be yes or no, depending on what the Supreme Court says. My other question would be, at least twice in his judgment, Judge Mosley writes that the police had all the tools to intervene, and that the regular laws were sufficient to intervene, at the exception of Ottawa, and we know that most of the situation happened in Ottawa. So I was wondering if those two mentions in the ruling could be used in the appeal to maybe draw a different conclusion.
Right, I don't, yes, he does say that twice, that he says that in Alberta in Ontario and in Quebec, the existing laws, including the existing provincial emergency laws, were used to deal with the protests and the blockades. I think practically speaking, what happened in Ottawa is it was only once the OPP cleared the Windsor Bridge, and then those police officers came to Ottawa to help the Ottawa Police Service clear Ottawa, that they were successful in clearing those blockades. So it was not a question of lack of legal resources, it was a question of lack of human resources to do the job. So I don't think that's vulnerable on appeal.
Okay.
And sorry, that was Eva again. Sorry, there you go. Okay, all right.
Next question is from Jim Brunskill at the Canadian Press. Please go ahead.
Hello. Further to Elaine's question, in addition, there's evidence, and this appeared at the Rouleau Commission, that Ontario was less than cooperative with the federal authorities and didn't even show up to an ad hoc roundtable that was struck to deal with the issues. So if a province refuses to assist the government, that is different from capacity, of course, but if they are uncooperative, is that not a legitimate ground for invoking the act?
I think Justice Mosley leaves the door open to that question in his ruling. He does discuss that. He does discuss what happens if the province it's not just legal capacity, but also, as you say, real factual capacity to deal with the problem. And he does leave it open that if a municipality or a province is unable to act or unwilling to act, that maybe it will be justified for the federal government to act. He does leave that open, but he says that that really wasn't the case here because Ontario did, in the end, participate and did provide significant resources in response to the Freedom Convoy once the Windsor Bridge was blocked.
Follow-up?
If you could identify who as a...
Sorry, that was Eva again. That was
because
Eva.
it is very difficult for us to know.
Sorry, that was Eva again. Ewa Krajewska.
Thank you.
Thank you.
Any further questions from the phone lines?
Not at this time.
Okay, seeing as how there are no further questions, this concludes our press conference. Merci beaucoup tout le monde. Ceci met à terme la conférence de presse. Bonne journée.
Great job, everybody.
Thank you.
Great job to you. Thank you.
Thank you for coming.
Thank you for
Thank
being
you.
here. It's such a big moment.
Hi. Hi, Chris. Yeah.
What are you looking for?
That's fine.